Hey everybody, estate planning is an essential part about your wealth planning that most people ignore. Debts and tax is something you cannot avoid, so let's proactively plan that for yourself, for your business, and for your family. Today we're going to interview one of the very famous lawyer, Peter Lam in Neverford. Let's go.
I'm here with Peter Lum and Steph Schaefer, the team at Neverford who look after estate planning. So today we're going to talk about the importance of planning your will, about organising your estate so that it's handed down to your family. So thank you so much for joining us today. Peter, can I ask you, what's the difference between making a will and an estate plan?
Well, a will is a legal document where you appoint executors to look after your estate, and you set out how whatever you might own is to be passed on to family or beneficiaries. That's can be a fairly straightforward document, or it can be a fairly complex document, depending upon the things that you're trying to deal with in terms of family or the nature of your assets. An estate plan is a process where people like us have a look at your family situation, your financial overview of the financial situation, to suggest to you the most flexible and tax-effective way in which you can pass on whatever assets you might have or control to family or whoever you want to benefit.
Right, yeah.
So one's a process, the other's just a straight legal document which just purely deals with how you want to leave things.
Right. So why do we need an estate plan?
Well, an estate plan helps you make sure you don't forget things, in which you might do if you just do a simple will and leave things directly to whoever it is you want to benefit. An estate plan goes beyond that. As I said, it's a process where your situation is looked at, and there may be, and it's increasingly common for people to own things not in their own name, but in trusts or companies, things like that. It's absolutely essential that you look at all those additional matters and bring them together into a plan where it's not just a will, but there may be other things that need to be done, either in the will or outside of the will, to capture everything that you own or control and make sure it ends up where you want it to end up. Or being controlled by who you want it to be controlled by.
Right, so it's really having control of the things that you've put so much time and energy in your life's work into.
Passing on control, and that's often overlooked in just doing a straight, simple will.
Okay. And Steph, can I ask you, what happens if you don't have an estate plan?
So if you don't have an estate plan, or if you don't have a will, essentially all those decisions are outside of your control. It's all kind of set out in the Probate Administration Act. It sets out who has the right to deal with your estate and deal with your assets, and how also your assets will be distributed. And that's all dependent on whether you have a partner, if you have a child or children, and the Act sets out how that's to be dealt with and also in what proportions. So it means that essentially you just lose control of the decision making.
Okay.
So
again,
it is,
that you've worked so hard for, everything that you've worked so hard for your family, to pass on to your family. So Peter, what's actually involved in making an estate plan?
Well, I perhaps should have said before, the reason you might need to think more carefully about how you deal with whatever you have to deal with is that there can be a whole lot of different situations that affect people. There may be a second marriage, there may be children of one marriage and then a later marriage. There may be a family business that you're concerned about how that's going to transfer over. There may be assets which you want to protect, and you might have children who are potentially vulnerable to claims, and you would probably be most upset if your inheritance ended up with their creditors. And there can also be tax, a certain element of tax planning that can be built into an estate plan to make it a bit more tax effective as to how assets move across.
Yeah.
So those are the sorts of things that give rise to the need for an estate plan. But in terms of how you do it, what we do generally is try and get some understanding from the people that we deal with as to what their family situation is, what children, what dependent children, adult children, grandchildren.
Divorces, yeah,
all of that. Then we try and get a bit of an overview of their financial situation. We don't need to know precise dollars and cents, but we need to have a bit of an idea what the size of assets might be, or value overall of particular assets, and more importantly, who owns them, because often people regard assets as assets that they own, but in fact they're owned by a company which they might happen to be a director of, or they're in a trust fund that they may control or may control with others, or they might have property which they treat as their own, but it's in fact a jointly owned property that's owned with a wife or with someone else. So we really need to tease out all that information so we can get a bit of a picture as to what the situation is for the will maker and the will maker's family. And once we've got that, we can then suggest things that they might need to think about in forming their estate plan, and what needs to go into their will to fit in with that estate plan.
Yeah, so you cross all the
and
T's and dot the I's, yeah.
because one of the things that people tend to forget about sometimes is insurance that they might have, which is linked to their superannuation. So they might say, oh well, I'm not worth a great deal at the moment, but when they do pass on, there may be significant insurance which comes into the estate or goes somewhere if they've nominated beneficiaries. But and the same for the superannuation. So that's the sort of thing we do to get it underway.
Yeah. You guys know what you're doing. Steph, do you have to have a lot of assets and wealth to make an estate plan?
So an estate plan, it definitely should be considered by anyone that does have complex assets or a high net worth, because it's going to reduce the risk of not being able to control where your assets are going, or passing to the beneficiaries that you intend to pass assets on to. But in saying that, it's not just the rich that should do some degree of planning. We all have assets, we've got super, bank accounts, and those things need to be taken into account. So some degree of planning is needed for everybody, not necessarily the full thing, but at least a will. And it's not always about just talking or looking at the assets you have right now, because the will is when you die. So it's about planning what assets you may have at that time as well. So yeah, it's not just the rich, it's not just the high net worth, it's really anyone should be looking at it and considering doing something.
Is there an age where you should plan your estate?
Under the Wills Act, I think it's 18. You need to be 18 to make a will. Otherwise, I know you can make an application to the court if you're under 18 to make a will as well.
Yeah. Do most people make their wills when they're, middle-aged, or I don't know, when they come into a large amount of wealth?
Peter might agree, but I think it's always on people's to-do list, but it's always right down the bottom. They know that it's something that they should be doing, but it's not necessarily something that they have done. And it's usually some sort of life event will trigger them actually into actioning, making some sort of plan. Yeah.
Like, I'm going away overseas next week.
Yes.
I need a will.
I can understand that. I'm going into hospital. I may not survive. What can you do for me? Why should people not do it themselves? Like, for example, with a post office kit.
Yeah. So the post office kits and even online wills, things like that, they're a very basic document. They're a stock standard template. So they don't take into account any of your own circumstances. It's essentially a set of preset questions that you answer, you fill in the blanks. So there's no consideration of, like Peter said, the family situation, your assets, your debts, whether you've got companies, family trusts and things like that. So when making a will or an estate plan, you do actually need to consider everything, and those pre-made plans don't do that. So they can be a bit tricky and a little bit dangerous.
Yeah. Peter, do people come to you too late?
Never too late.
Never too late. So you give me 90.
If you're still alive and you've got legal capacity, and that's where people sometimes get caught out, because they put off making wills because they think it's going to be some sort of put some blight on their lifespan. But there is a risk well, at any time, but certainly as people get older, that they may lose capacity to make decisions and make a will. Then you're in a situation where you might die without a will, and you have what's called an intestate estate, where next of kin or have to apply for letters of administration, and the estate gets distributed in accordance with the Administration and Probate Act, which I think Steph's going to be talking about in a minute. But so no, it's never too late, provided you've got that capacity to make decisions and make a will. Yeah.
Okay. So where do you start when making an estate plan?
Well, as I was just saying a little while ago, it's a process of going through that family situation of each will maker and financial situation in terms of what they own. So if they come to someone like us, they'll probably get a checklist which needs to be filled out with the sort of initial information which we would need to start to work on an estate plan for them. And then usually there would be an interview to add a bit more detail to that information and understand exactly what the wishes are of the people concerned as to how they want things dealt with if they're not around to do it. And in terms of passing on to the next generation or to whoever their beneficiaries might be. So that's the sort of process to get it underway, and obviously to provide that information, whoever's making a will needs to know what they do own and have some details about that, and details about their superannuation and life insurance and any shares or investments, details of any business that they're involved in, that sort of information.
So what are the biggest and most common mistakes that people make when it comes to this?
Well, we've just been talking about one of them, which is to do your own will.
Yes, so there we go. Mistake number one.
And,
or don't do one at all.
Yeah, or not make a will. That's right. And that, can manifest itself in situations where someone writes something in their will kit as to what they want, which is very unclear, and that puts a very unfair burden on their executor in terms of how to deal with the estate when they've got unclear instructions. And it can also cause dreadful disputes within a family if it's unclear who's to get what, or there's some question mark because you haven't dealt with some part of your estate. So it's a bit of a false economy usually to do those. But so that's one thing. Other common mistakes are, as I was saying before, is to not really understand how assets are owned, and there may be things that you control, but you don't actually own them. They're not in your name, and so they won't necessarily come into your estate to be dealt with in accordance with your will. So they've got to be covered in some other way, so that you can be comfortable and assured that all those assets which are not actually in your name are going to end up where you want them to end up. People sometimes want to exclude particular beneficiaries, family members, and there's always some difficulties about that, in that they might have good reason for doing that, but it doesn't prevent that person, if they're an eligible beneficiary, from making a claim against the estate at some later time. There are some things you can do to mitigate in terms of providing proper explanation as to why you're excluding that beneficiary, which could be highly persuasive if there is a dispute down the line. But sometimes people just leave people out and without any explanation, who would otherwise expect to be included. People forget about their liabilities sometimes. They might have a number of trusts, and there's a whole lot of interlocking loans, and it may mean that something they leave to one beneficiary is going to be diminished because of a liability that they've not thought about. So it's another problem. There's sometimes it's a common mistake that we assume certain people are going to be still living and that others will not be, in terms of who you appoint as trustees or executors, and none of us have any assurance as to how long we're going to live. So, for example, if you're appointing executors, it's not usually a good idea to appoint people older than yourself, but if you do, or even if you appoint ones of similar age or younger, it's good to have alternates, and you need to also think about if you're appointing trustees in a will, whether they're going to be around to do the job. So there's a few things. People sometimes worry about the cost of getting an estate plan prepared, and in conjunction with doing a will. When you look at their total asset values and net worth, the cost is minuscule. It shouldn't be something that deters people from doing this if they potentially have these sorts of issues. So there's some of the things that crop up, and there's lots more.
Yes, I'm quite sure. You've seen probably everything over all these years. Steph, can I ask you, you're just about to graduate. What makes you enjoy or want to be an estate planner?
Yeah, so for me personally, I've seen my own family go through disputes when it comes to deceased estates, where there's either been a will in place and there's arguments between family members about how it's actually been set out and they're not happy with it, so it breaks the family apart. And also where there hasn't been a will, and people that thought they should get something haven't gotten something because it's all set through the Act. So I can see how it can actually fracture a family. And I guess that's kind of why I am interested in this area, because it means that you can assist the clients with making sure that their wishes are actually dealt with. It's all done in accordance to what they want, or as best as possible. So yeah, for me it's about helping the clients to avoid those tricky and awkward situations with their family after they have passed away. Yeah.
Peter, what's a Okay, I'm going to
A
try this again.
testamentary trust.
Testamentary trust. And how did, obviously I don't know, so I can't even pronounce it.
Lawyers spend a lot of time making up this terminology.
I'm sure. If it doesn't have 3 syllables, it doesn't belong in a law firm. And how do these work?
Well, they're now a lot more common and often used in wills. It's a factor of the fact that we've had a number of generations in Australia that have been that have become reasonably wealthy in the post-war years, and we often hear the term baby boomers, which and because we've had a relatively affluent time in Australia over some period of time, people have accumulated assets, and testamentary trusts are essentially, the simplest way of explaining them is it's like putting a discretionary trust in your will. But unlike a normal family discretionary trust, which works while you're alive, the testamentary trust commences when you die, when the will comes into effect. And why people use them is it's an opportunity to put assets that they might have or divide them between, say, they might have 3 children. They might decide, well, we'll set up a fund in our will for each child, and the beneficiaries of that fund can be that child plus any children they have, and so on in each child's family. So it's like a trust for each child and his or her family, and the advantage of these sort of arrangements are that it creates some flexibility for those children in how they receive their inheritance, and they can distribute to their own family. There's under current tax law, there's a concession for dependent children of a testamentary trust. So that's one that comes out of a will, where they can receive the same tax threshold as an adult, which means that you can distribute at the moment about $18,000 a year tax-free for each of those children. And if you're paying school fees, they can be applied in that way. There are other reasons why people use these trusts. Sometimes they might have a vulnerable child who might have a drug habit, or some other reason where they can't make sensible decisions about what they might receive from you by way of an inheritance. And you can appoint trustees to manage this fund for that child. If you have a child, I think I mentioned earlier, who might be a lawyer who can get sued, or a doctor, or in any professional job where they might get sued by someone in the course of what they do, then it's not a great thing for them to receive their inheritance in their own name. If it's received in the trust via the will, there's a level of protection from their creditors, because it's in the trust and it's not personally owned by them out of your estate. So that's, in a very simple terms, is how testamentary trusts work. Technically, they're called discretionary will trusts, but and they've become a very useful tool.
Okay, yeah. Steph, how will marriage affect estate planning?
Yes, so under the Wills Act, it kind of helps us when it comes to marriages and divorces as well. So under the Wills Act, essentially when you get married, your will is automatically revoked. It's a clause, so as soon as you get married, if you have an existing will, it's automatically revoked. There is an exception to that though, and that's if you've made your will and it expressly says, and it's clear that you've made your will in contemplation of marriage. So if you're engaged and you want to make a will, you would always put in a clause that specifies that you understand that this will is being made in contemplation of marriage to such and such. But when you flip that and it comes to divorce or even separation, it's not automatic. So if you are if you're separated, or if you're going through family proceedings like property settlement or parenting disputes, your will isn't automatically revoked. It's not until you're actually divorced that the will is automatically, or sections of the will are revoked. And that's when it comes to gifts to your ex-spouse, or where they're appointed as an executor. So I think the lesson is that whenever you're getting married or divorced or separated, you need to consider looking at your will and amending it.
Okay.
Yeah.
Yeah, don't just assume. That's because I'm not.
Never assume anything.
Yeah, never assume. Never assume. Okay, that's great advice for my next marriage. I'm joking. Okay. Some people think it's a pity that people sell their parents' or grandparents' property portfolio after their death, rather than retaining the family wealth in a trust or existing structures and setting up a family office to keep growing those assets under the trust for present and future generations. In your experience, Peter, are such arrangements becoming more common?
I think they are, and it's a result of what I was talking about before, that some families have accumulated significant wealth, either through the family business, or through a property portfolio that they may have built up over the years. And there is sometimes a desire to preserve those wealth assets for future family members, rather than have it all just go out the door when you die to your immediate beneficiaries. And in those situations, they can be quite complex to achieve that sort of result. And it's a matter for the family to balance the pros and cons of doing it. There's a temptation on some part of some people to want to, as we say, legislate from the grave, and be too prescriptive as to what's to happen when they're not around. And invariably that doesn't work very well, because circumstances change, or there's arguments and disputes or whatever. But on the other hand, there can be considerable advantages for a family group if they're able to come to some reasonable form of agreement to preserve family assets, or certain family assets, for the benefit of future generations. But to put something like that in place is quite a complex sort of, well, not complex, but it requires a lot of thought, and the family need to all be on board as to how that's to work. Yeah, because you're talking about if there's a family business, who's going to run the business? And not all family members may be appropriate to be involved in that, and sometimes it won't work because the synergy between family members is not right. So you've got to try and balance that, and that's a discussion that can be assisted with families, but which those families need to have. And they might reach a point, and it's becoming more common, where there is this significant wealth there's a lot of advantages in preserving, and there may be tax reasons as well, where there may be some sort of agreement between family members. They might even have what's called a family constitution to set out certain guidelines. Or some other form of arrangement. Some families, if the assets that they're managing are significant enough, might have a family office to manage those assets. And then there's a matter of having an agreement. Well, who's going to run the family office and have direct day-to-day control, and what will be the rights of the other family members so that they don't get shut out of that. So
Very complicated.
it's an interesting process.
Is it common?
It's becoming more common.
Really?
Yeah.
Okay.
Yeah.
Yeah.
Yeah. You don't hear about it a great deal.
No.
But you do hear of families like the Meyer family that run a family office, and but on a smaller scale, there are other people are now forming those sorts of arrangements if the situation warrants it.
Right. Well, that's so interesting. How do you take advantage of education funds in estate planning, and what are some of the tax considerations?
Well, I'm not a financial advisor, but there's the two obvious ways are that you can buy a product, an insurance product, and there's quite a few of them on the market. They've been around for a long time, education bonds, but I'm told that the current sort of products are more tax effective than they used to be, and essentially what happens is that grandparents perhaps can decide they're going to put money aside for education for grandchildren, and they can buy these bonds, and the money comes out to feed the school fees. And it can be a reasonably tax effective way of doing it. Or they might decide to set up a fund or divert funds under their will, so that when they're gone, when they die, their assets or a proportion of their assets are set aside in a fund under their will to be used for education purposes.
For the grandchildren?
Yeah, and as I was explaining before, at the moment there's a tax concession for up to the adult threshold in terms of receipt of income, so there'd be some tax saving there.
Right.
That there are other tax advantages or considerations that relate to the use of testamentary trusts, in that you can move assets. Currently, if you own real estate and you transfer it, duty may apply on the value of the real estate that you're moving. There are certain exemptions under the Duties Act, and I don't want to get too technical about it all, but one is a exemption if property is transferred out of a deceased estate to a beneficiary. It's been around a long time. Or if it goes from a deceased person into a testamentary trust they've set up. And then there are other exemptions available under the Duties Act which may permit a transfer of that property to a trust of a beneficiary or to a beneficiary without incurring duty. So there's savings there, or at least there's existing exemptions which you can take advantage of and enables a more flexible distribution of assets. Capital gains tax always rears its head in these situations. I should say, when we do these estate plans, and if the assets are a little bit complicated, we like to do it in conjunction with the accountants that act for the client and their financial advisors. So we get input from different sources. And in relation to capital gains tax, it's there may be considerations about preserving a exemption for the main residence, the principal residence that the deceased person lived in, if some beneficiary is going to use it as their principal residence. So there are a lot of tax considerations that we, in conjunction with the relevant accountants, try and have regard to when we're working these things out.
Yeah, wow, there's a lot. Steph, can I appoint a guardian for infant children in my will?
So if you do have children under 18, it's always important to think about including a clause in the will expressing who you would want to appoint as a guardian, but saying that it's not legally binding, but The ultimate decision is made by the court when you do pass away, who's appointed guardian, but the court will look at that clause and give a lot of weight to that because it is an expression of your wishes. So it does weigh heavily on their decision, so it's important to include it. But in saying that, you need to carefully consider who you appoint as a guardian, because essentially they're going to be raising your children, so do they have the same lifestyle that you have? You know, if you're appointing, say, grandparents, they're going to be slowing down. Are they going to have capacity to look after your children? Are they travellers? Do they travel a lot? Do they have the financial means to look after your children? Is there any religious kind of considerations to be made as well? So it's a big decision. I'm not a parent, but I've had this conversation with plenty of my friends, and it's something that terrifies them because it is a big decision, but it is important to have that conversation with the person that you are going to say, I want you to be the guardian of my children, because that's putting a big burden on them as well. So it's important about having conversations with them, giving them the space to think about it, because you don't want to say, I want you to be the guardian, and then they turn around and say, well, no, it's too much, sorry. So you can include it. It's an important thing to think about, but it's important to remember that it's not legally binding. It's there just as an expression of what you want.
Does it have any weight?
The court will take a lot of consideration, like they will consider that clause a lot in their decision. Yeah.
Okay. I thought it was a legally binding thing. So yeah. Peter, can potential beneficiaries miss out on money from their parents if there's no will, or if it hasn't been updated, for example, in relation to superannuation or life insurance?
Yeah, well, there's the courts are littered with cases of
Yes.
beneficiaries who felt they've missed out. And it can happen if there hasn't been some sort of planning by the person making the will, or some thought given to how it's all meant to work. And certainly if there's no will, as I think we touched on, the whatever you have will be distributed in accordance with the Administration of Probate Act, which is essentially to partners, children and relatives, but or close relatives, but it may not be the way you want it to go. The danger, one particular, an obvious example that crops up is in relation to superannuation. And effectively in superannuation you can either nominate who you want when you die. There's a death benefit paid. Right? Let's go back a step. And you can nominate where that's to go to a dependent. So it might be a spouse or a partner or a child. And if there are no dependents, or if you don't nominate, it will usually go to your legal personal representative, who's if you have a will, is your executor. And where people miss out sometimes is that either there's no advice, they need to get advice from people like us as to whether they should nominate or not nominate. But sometimes if there hasn't been proper thought given to who's going to be controlling the superannuation fund, and I'm talking about self-managed superannuation funds, sometimes the control might fall to someone who then directs those benefits in a way you don't want.
Yes.
And so that's how people can sometimes miss out.
Yeah, again, it's
So
taking
by
away
not
control.
by not thinking about what's to happen with things like the superannuation fund or insurance policies.
So how can you minimise disagreement amongst the that's like, how can you stop family arguments, basically?
Well, the litigation lawyers would say, why? What do you want to do that for? But the whole point of estate planning is to try and minimise that risk, and it's always a bit of a balance, and depends on the family situation whether children or beneficiaries should be taken into the confidence of their parents when wills are being made, because sometimes there can be a temptation for there to be interference with what the parents want to do. And it's important for any lawyer when they're taking instructions in relation to a will to be satisfied that these are the genuine wishes of the person making the will. But having said that, the one way to avoid disputes is if there is some level of consultation, so there's no big surprises for the family when the will actually comes into effect or the estate plan. So it's a balance between consultation or advising family members or keeping them informed, but not having them dictate what's going into the will.
Yes.
And if there can be some level of consultation, or usually that goes a long way to avoiding disputes down the track.
Yes, yes. Steph, do people need to do powers of attorney and appointment of medical treatment decision makers?
Yeah, so when we work with clients for estate planning or making a will, it's always a question we ask, that they think about making an enduring power of attorney when it comes to financial and personal matters, and also the appointment of medical treatment decision maker. It is a mouthful. And essentially, if you don't have those documents, again, it's that control. You lose control of who's going to be making those decisions for you. So if you don't have the enduring power of attorney, there's going to be a guardian appointed who will make those decisions for you. Same with medical treatment. If you're not appointing somebody that you trust and you know will respect your wishes, again, there's no control over who makes those decisions. So it's all about, I think it's come across through the whole discussion, is that control of what you want is important, and that's what those documents do. They set that plan out.
Yes. Yeah. So that your wishes are, there's no doubt whatsoever.
And people will look after you. They'll do what you would have wanted them to do. Yeah.
So how long have you both been doing this for, Peter?
That's an awkward question. 40 plus years.
40 plus years, so you must love it.
Oh, I haven't been doing just this. I do other stuff as well, but in commercial area. But I'd have to say estate planning has become a bigger part of what I do over the last few years. I mean, lawyers have always made wills, talking about lawyers in general practice, since the year dot, but estate planning has certainly become very important over the last 10 or 20 years.
Yeah, and I bet you've got some stories to tell. I bet you can come home with, well, you're not going to believe what happened today.
Perhaps I should take a leaf out of your book and write a book.
Absolutely. Thank you so much, guys. It's been just lovely, and I've learnt so much. I'll be booking in for it.